So, welcome. We have Heidi Tandy, who is a lawyer who's worked on issues relating to fans and fandom for well over 10 years. And more recently, along with part of the Organization for Transformative Works, which is a nonprofit that I also work with, focused on defending the interests of creators of non-commercial fan works. Yes. Did I miss anything?
I think that's a pretty good overview.
Okay. And then we're also fortunate to have another person connected through Harry Potter, as I was just reminded, Dale Nelson, Vice President at Warner Brothers and Senior IP Counsel, who has also been working in the field for 20 years and has some interesting perspectives to offer about fans and the relationship between fans and mainstream content producers. So Heidi's going to start us off.
Okay. Thanks, y'all, for being here. I actually started out relatively long time ago when I was an undergrad here at Penn making videos about spring fling for my class graduation. I ended up being called back to do our 20th reunion one last year, and because of that I've put together a little video that sort of covers some of the topics that I'm going to be touching on, that we're going to be touching on, going a little bit beyond fan fiction itself into other types of fan creativity. Probably, as most of you know, fan creativity is as old as storytelling. The idea of things being original, or the idea that something would not build on all the stories that came before, is really only a conceit that we've had maybe in the last 150 years. In the online era, however, distribution's gotten a lot wider, and our compulsion to have fun with something we love not only impacts the people around us who we're storytelling to, or showing art to, or putting on plays with, it impacts the intellectual property of the underlying work. Or at least it can if the work isn't in public domain. If you're Joss Whedon and you want to do a Shakespearean play, nobody is going to have any copyright issues with regard to that. If you, however, want to do a live sing-along of Once More with Feeling, then you're probably going to have to get permission from somebody to be able to show it in a large setting. There's lots of different kinds of fanish creativity that we're seeing online every day. It's not just Threadless's shirt of the day, it's Batman Memorial's Stephen Colbert and the Eagle of Truthiness otters that look like Benedict Cumberbatch, 50 Shades of Grey, District 9 3/4 Quidditch Team t-shirts, and so much more. Fans who love to play with their favorite books and shows look to the Copyright Act and occasionally to trademark concerns, and to the legal protections given to transformative works, which have gotten really a lot broader in the last 10 or 15 years, thanks to cases that have absolutely nothing to do with fanish interaction, but rather have to do with things like Google wanting to be able to put thumbnails of art up onto their search engines. Unfortunately, or fortunately, because of so many changes and because of just the spread of education and the fact that these things are being created by 10, 12, and 13-year-olds, as well as college students and people in their 30s, 40s, 70s, and 90s, there's a lot of confusion and paranoia about how things actually work. We all know and accept that laws that protect fan creators exist, but there's also a lot of gray areas, even for non-commercial works. So we're going to take a look over here, if I can figure out where the start button is, and take a brief look at about 15 different types of creative works and some discussions between creators and fans on topics like fan fiction and fan art. So hopefully it won't be too loud. Should I turn it up? passcoded this, and it sat down a little bit too long. Basically, I've been involved in fanish creativity and protection of fan creators since probably 1999-2000. I started my legal career on the corporate side, representing Condé Nast, Ringling Brothers, lots of real estate companies, did terms of use agreements, New York Times, did a lot of COPPA work when it was starting up, still do lots of trademark search reports. But in 1998, I read the Harry Potter books, and then I started getting involved in fandom. Was on staff for the Leaky Cauldron for a number of years, set up a bunch of websites, helped a lot of other people set up websites, basically handed out terms of use agreements to anybody who wanted to create a site, and also at that point try and give themselves a little bit of protection if people were uploading, say for example, actual files of movie trailers, because back in 2001, 2002, there was a lot of concern among fans that if you took a movie trailer that one of the movie companies had uploaded to their website and you shared it on a, say, for example, Yahoo group, someone who didn't like you could come and complain to Yahoo, and they would delete your entire group, your entire member list. You'd never be able to find anybody again, and all your messages would be deleted forever. That doesn't happen anymore, thankfully. And a lot of that is because of interaction between fans, between the creators of the underlying works themselves and the corporations who have developed methods for dealing with that sort of thing that don't involve wholesale deletion of thousands of hours of people's time and posts and interactions. Rebecca and I were saying before we started our panel here, it's been about 10 years since we started putting together our first sort of parcel tongue for non-lawyers panel at Nimbus, the first Harry Potter fan con back in the summer of 2003. And at that point, we were really trying to explain to people how copyright could not only be used as a tool against them, which was what a lot of people were afraid of, that the powers that be would come down and delete their works and sue them, not just take their stuff offline, but would sue them for $10,000 for each infringement, and would each infringement count as something every time somebody had downloaded or every time somebody had viewed it? Would they, seize their computers, which were a lot more expensive back then than they are now, et cetera, et cetera. So people were also afraid, much more afraid back then, that their name would become public and they would be associated with fandom, and that would ruin their career prospects for the rest of their lives. That doesn't happen as much anymore, but it definitely still is an issue for some people. As you saw in the video that I put together, there's a whole bunch of types of fanish creativity. Obviously, there's fan fiction, there's fan art, which you saw a couple of examples up there. There's memes like Snape's on a plane and the Rickroll. But there's also a lot more of an expansive world out there. There's music that is based on fanish creativity. And obviously, there have been, songs that have been published and distributed by mainstream musicians for years, things like Five for Fighting's Superman song from about 10 or 12 years ago, and pretty much everything that was ever done by the band Yes, which is mostly Lord of the Rings based. But in the last 10 years or so, starting mostly with Harry Potter and Wizard Rock and a few different Lord of the Rings fan projects, going all the way to things that are going out now like Rocking Jay, which is based on Hunger Games themes. There's also a lot of content that's being created and distributed because the creative process and the creative methodologies have gotten so much easier. People can now do this, or have been for the last few years, been able to do this in not just a garage band area where you can perform and present and make tapes and CDs for your friends, but you can get worldwide distribution for your content. And as we've all seen in the last month or so, something like Star Kid Potter's A Very Potter Senior Year came out and basically had 1 million views within 24 hours of people who had been waiting 1, 2, or 3 years to see what really is their final version of their Harry Potter fan musicals. Going back to the gentlemen and their games discussion, there have been a few recent situations where fan art that's been created within the fandom and by fans for fans has been taken by the owners of the underlying work, but they haven't taken it willy-nilly. They've gone and either purchased all the rights to it or they've licensed it, and now the people who have were creating fan art just for fun and for distribution on Tumblr are now finding themselves with contracts with the BBC with lithographs being sold of their signed art, which is awesome and would have been completely unbelievable if you'd told somebody that in 2008, much less 2002. But there's still definitely some friction between fan creators and the creators of the underlying works. About 2 or 3 years ago, an author named Diana Gabaldon, whose most popular stories started, as she says, as Doctor Who fan fiction in the early 1980s, changed her mind about it a little bit and said that fan fiction was like, let me get her exact words, was like seducing someone's husband or stealing flowers from her garden. Now, obviously, she's totally allowed to feel that way, but what she can't do under current copyright law and trademark law in the United States and also in the United Kingdom, which is where she's based, she can't stop people from discussing and analyzing her work, even if they do so using creative methods like stories, like art, or like fan films. So after ranting about the evils of fan creativity, she actually ended up deleting her original post and said it never occurred to her that fans would create works inspired by their stories because they love the stories. I think she thought they were doing it because they hated her or out of some misguided revenge, although the logic of that has always escaped me. But both before and since her screed, other creators have been much more appreciative or at least understanding of why fans create works, discussions, events, role-playing Twitter feeds, Tumblrs, and so much more. I had a screen cap up there. I'm not sure how clear it was, so I'll upload the whole thing so people can see it. From a discussion earlier this spring between novelist S.E. Hinton, who wrote The Outsiders, and one of the creative people on staff for Supernatural, which is one of her favorite shows. She tweets about it all the time, especially on Margarita Fridays. And they went into a discussion on Twitter in front of everybody about how some real-life photograph showed basically supernatural hunters from some time ago, and they discussed the idea of the two of them doing a fan fiction using exactly that term about it. And we also had a screen cap up there of Greg Berlanti and Jeff Davis talking about certain Teen Wolf ships becoming canon, and again talking about fan fiction, and that's things that are coming directly from the creative team. You can find people like Clark Gregg from the Avengers who basically retweet fan art, and people from Lost do that as well. And that's the sort of thing that never would have been comprehensible to any of the Nervous fans or the Nervous show creators, 5, 6, 7 years ago, because it was just something that was considered barred, or at least under concern of copyright law. You couldn't allow people to know that you were looking at things. Obviously, most of the time, as we all know, the IP is not necessarily owned by the creators. So all this, yay, this is wonderful, is all well and good in its place, but you still have situations like the current Veronica Mars Kickstarter, where Rob Thomas had to go to Warner Brothers to get permission to basically recreate his own story in a new format. So it's going to be interesting seeing how that sort of thing develops, if more creators try to do that with corporations, or if they try to have some sort of a holdback or a turnback of their work after a certain period of time has passed so that they can use it creatively in their own way going forward. I know I'm running out of time, so I just wanted to very quickly touch on again, the intersection between fans and the multinationals behind the products that the fans are often creating works for. And that's the recent case involving Universal, where they sued Smash, which is a porn company, who did actually make a porn version of 50 Shades of Grey. I know that pretty much sounds like what it was supposed to be. And in one of their pleadings, Smash, that's the porn company defendant, said that the novels themselves were public domain. So we ended up with these awesome briefs written by Universal's outside legal counsel that were basically coming out swinging in defense of the copyrightability of fan creativity. Basically, one of the things that Universal ended up saying was that defendants do not and cannot provide any legal authority for the proposition that an earlier version of the work is now in the public domain, and they can hardly defend their infringement of plaintiff's copyright in the 50 Shades trilogy by complaining that it is substantially similar to her own earlier work. So with where we were as fans in 1999 and 2003 and 2005, to now have a major corporation for their own interest, for their own reasons, saying that fan creativity is copyrightable, it's protectable, it's owned by the fan who created it, is just such a sea change from where I think we expected things would be at this point. And I think it's going to be interesting to see how things transpire and develop as more social media, as more interactive, interactivity happens between the creators and the fans and between the fans themselves, and we'll see what people continue to do. Thank you.
Is it going to come up by itself? Forward? There it is. Hello, everybody. My name is Dale Nelson. I'm an intellectual property attorney from Warner Brothers. I'm really thrilled that I was invited to join this panel to talk to you all about fan activity, which is, I think, an issue that is extremely interesting and has, as Heidi said, developed a lot over recent years. As an intellectual property lawyer, I find the issues fascinating, and they continue to evolve. I also very much appreciate the opportunity to talk to students and people interested in intellectual property law to hear us out from a corporate creator's point of view, because we've heard a lot about the fans' perspective, and maybe people don't always have an opportunity to hear the corporate perspective. So I really appreciate the opportunity to do that, and I was encouraged to hear in the last panel some references to large corporate copyright owners making accommodations for fans, and Heidi was doing the same thing. So I'm really glad to hear that, because I think sometimes there's an undercurrent of thought that large corporations that are copyright creators are somehow against fan activity or don't allow fan activity. That's not the case. We know that our fans are consumers of our properties, and we certainly don't want to alienate them. And so there's a fair amount of encouragement, tolerance, acceptance, and an attempt always to try to strike the right balance. And I'm here to talk a little bit about that. So I just want to preface by saying that the opinions that I express here are, for the most part, personally my own. I do work for Warner Brothers, but anything I say here today is not necessarily a reflection of the view of Warner Brothers. So I wanted to get 2 points, I think, across today. One is that Warner Brothers is both a creator and a user of copyrighted works. We create a lot of films and other properties, which of course we want to protect from infringement. But at the same time, we're a creator that uses other people's copyrighted works. So sometimes, for example, in making a film, we will use copyrighted works in dressing our sets or in dressing our actors as props. We use things, we do clearance analyses all the time to determine if something's non-infringing, or if it's public domain or fair use, or we end up seeking permission. We also do a lot of work in protecting our own works from infringement. And we respect the non-infringing and fair uses of our own works. Again, we're on both sides of the issue, so we try to strike the right balance. We're very conscious that we have a First Amendment right to use certain things in our own creations, and we don't want to unfairly take a position one way or the other. It's all about striking a balance. When it comes to fans, then we, even though technically under a legal analysis there might be something that's infringing or isn't a fair use, we have taken the position sometimes that we simply won't object, and we will tolerate it because it falls into this basket of fan activity that we feel can coexist with our own exploitation of our properties. So how do you determine which is which? Sometimes it's not easy. And I wanted to also point out that, when we look at fan activity, it's within the context of all these other analyses of what are we using in our own productions, and are we entitled to do that? Or is somebody else using our properties, and is it infringing, and do we need to take some sort of action? Okay, so it's all analyzed together, and I think that it's important to know that that's our perspective. That's the lens in which we evaluate fan activity. So to make that point, I just wanted to give you a few examples. These are the usual tools from a legal standpoint. We're looking at and analyzing what comes along. Copyright Act, Trademark Act, states' rights of publicity often come into play. First Amendment, of course, is extremely important. We try to use a lot of common sense, and we're well aware of watchdogs. What do we mean by watchdogs? I mean these organizations like Chilling Effects, Electronic Frontier Foundation sometimes has a hand in this, and these are organizations that sort of watch and are very much aware and sort of keep tabs on big content owners and whether they're overreaching and whether they're abusing their rights. They look out for creators and users, and I think that these watchdogs create a nice dynamic in the whole area, and we are very much aware of what they're saying and what they're advocating, so that, again, we're trying to strike the right balance all the time. Chilling Effects Clearinghouse puts out these ratings sometimes about takedown notices and which companies are being good at it or bad at it, and I think Warner Brothers usually gets a pretty good rating out of this, so we're happy. We try to be responsible. Fair use, it's always a test of 4 factors, I think, as most of you know in this room. So it's necessarily always case by case. It's very dependent on the facts. You have to weigh all the factors. As Heidi said, in the fan community, there's sometimes a misunderstanding about the legal parameters at play. I hear things like, well, it's a parody, therefore it's a fair use. Well, parody is sometimes a fair use, but not always. You still have to balance all the factors. I'm going to try to talk fast because I know my time is limited. So using the tools. Here's some examples, which I hope will illustrate our lens or our perspective of what we didn't seek permission for. Okay, what we're relying on, fair use concepts or maybe public domain. So this is actually a short clip from a movie featuring Marilyn Monroe, and we had interposed here a drawing that was done by Bob Kane, the creator of Batman. And it was in a biographical piece that we had put out in connection with the release of one of the Batman movies. And the point made was that Bob Kane had some sort of a relationship with Marilyn Monroe in the past, and he actually used her as the model for Vicky Vale, who was Batman's girlfriend. So we put this in our piece, and I got a phone call one day for the lawyers for the Marilyn Monroe estate before she had all her right of publicity problems, and we had a conversation about right of publicity and fair use and copyright infringement, and fortunately that only took one phone call. But sometimes we have people questioning our right to use things, and this is one that we felt was a fair use. This is an illustration from a book from 1880, and I was asked to clear it. We wanted to use it in, again, some enhanced content material in connection with our release of the motion picture Red Riding Hood. This is an illustration from an old Red Riding Hood story, and I couldn't identify who the illustrator of the piece was. I think it says up there, illustrator unknown. But given the date of the drawing, we sort of did a rough calculation that it was probably in the public domain. Not necessarily, because some of the terms of copyright around the world are quite long and based on the death of the author. But we felt that, well, even though there might be a few territories where maybe the author is still living, if anyone could sort of figure out who it was, we'd take that risk. And so sometimes we do those kinds of analyses. This is a still from our Sex and the City 1 picture, I think. And this is Big in his apartment, and you'll see the book just underneath Big's arm with the illustration on the cover. We got a claim on that. Okay, you're infringing my copyright. Okay, this is a prop that are set set decorators put on the bookshelf in the apartment, you know, in part to sort of illustrate who the character is. And, you know, so it's just an illustration of the kind of thing we have to put up with. This is something our consumer products department wanted to merchandise in connection with Inception. Came to me for a clearance. You know, can we copy this and mass produce it? So, well, you know, if it were a different design, we might run a design search and double check that, but you guys, I'm going to kind of go out on a limb here and say that I think that die design is probably in the public domain. And those pawn pieces too, so are those bishops. But just to make the point that we try to be very careful not to infringe anyone's rights, especially in the merchandising area. This is a still from a motion picture that we made quite a few years ago called The Perfect Storm. And it is the story of, based on a true story of some fishermen who went out, I'm going to use this, who went out on that boat, got caught in this wave, and they all died, unfortunately, and no one lived to tell the tale. So when Warner Brothers wanted to make the picture, necessarily had to fictionalize what went on in that boat, the lives of the fishermen. We got a claim, a right of publicity claim, from the families of the deceased fishermen that we had used their names and their likenesses, albeit portrayed by Mark Wahlberg and George Clooney, in this commercial enterprise that they claimed violated the Florida right of publicity statute. We ultimately prevailed, but it took a lot of litigation. Another illustration of what we didn't seek permission for and what we feel we have a First Amendment right to use. But they didn't seek permission for. I'll try to talk fast because I know I'm... Okay, this was an example of a piece of art that was done by a British artist. And, you know, we looked at it because they're using our Looney Tunes characters and it might be of concern. But when we learned that the artist was trying to make the point about how our society has become desensitized to violence, and he was using the cartoon characters, what would it really look like, you know, if Bugs shot Daffy? We felt like this was an expressive purpose. I think they would have a good fair use defense here. This is a slide that shows a number of different, what we call companion books, Harry Potter companion books. These are all criticism and commentary on Harry Potter. You have Harry Potter and Christianity, Judaism and Harry Potter. If Harry Potter ran General Motors, I mean, any view you want to hear about on Harry Potter, you'll probably find it. We look at these books. We evaluate whether they're fair use. This is a collection of ones that are fair use commentary, as long as there's no likelihood of confusion or any other infringement going on. They're fine. This is one that is not okay. This was a case we litigated where somebody had put together a documentary about the life of Elvis Presley, but they used over 300 clips from our movies that contained entire performances, in some cases, of Elvis's work. It just did not raise to the level of a legitimate, fair use of clips. A biography of Elvis could be done in the right way. This was not one of them. And the court in the Ninth Circuit agreed with us. You see this kind of thing a lot. You know, people will say, oh, it's a parody. This is not a parody. This is not a fair use, and it also dilutes our trademark. This is kind of cut off, but it involves a violation of the right of publicity of Ellen. And I've got a lot of examples here, but I'll just sort of click through them. These are a lot of apps that we look at to try to determine whether they're infringing or not. Things, different websites, Facebook pages, and in the area of fan activity. So what's our view on fan activity? Fan activity is fans having fun with the properties, okay? When we evaluate fan activities, we really like to determine, are they legitimate fans? Are they doing something because they love the properties? Or they see fan activity as some sort of a loophole of somebody who might wants to make a fan film just because he wants to showcase his talent, but he's never even really read Harry Potter. we will kind of look at all the factors. What fan activity is not? Fans commercializing the property. As a copyright owner, as any copyright owner, under the law, we have exclusive rights to commercialize the property in certain ways. And so when fan activity starts to get into merchandising and things that really affect our business, we'll look at it, but that's usually a flag so that something is wrong or off. But we do tolerate a lot of types of fan activities. This is a classic fan film that's being streamed for free on YouTube. We've all seen this kind of thing. Websites. This is the Leaky Cauldron that Heidi referred to earlier. These are very popular Harry Potter websites. It's a Dallas fan site. There's a Lord of the Rings fan site. There's some Quidditch players. Harry Potter musical. But we have limits. Okay, and this is an example of fan activity limit where we drew the line. And some of you may be familiar with this case, the Harry Potter lexicon. It started out as a fan site, a Harry Potter fan site, created by this guy, Steve Vander Ark, who was a huge Harry Potter fan. And one of the things on his website, which we thought was fine, was a sort of encyclopedia, A to Z, all the things Harry Potter. And as long as it was free on the website, this way, it was fine. And J.K. Rowling even gave it a fan award. But somewhere along the way, Steve was approached by a publishing house called RDR Books. They said, we want to take your Harry Potter lexicon and turn it into a book that we want to sell. And I wasn't there, but I'm imagining in my mind that Steve said something like, I can't do that. That would violate J.K. Rowling's copyright. And RDR Books said, oh no, we think it's a fair use and we will indemnify you. And so he took the blood money and he made a contract and tried to put out the book. And I like this slide because it illustrates, I think, in our minds a little bit of what was going on here. You'll see most of the covers here are from the authorized Harry Potter books that were distributed in England, the first series as I understand it, and then down in the bottom in the left corner you see the proposed cover for the lexicon. And when you see them together there, you sort of get the feeling like, this wasn't quite legitimate. The lexicon also copied entire songs from Harry Potter and spells, copied J.K. Rowling's distinctive prose in some instances. And the entries for some of the characters, like here's the one for Harry Potter, just went on and on and on and on, giving away all the plot points. But the advocates for the lexicon in the case did provide a very compelling fair use defense in sort of the social utility realm of the fair use cases. And at the end of the day, the judge decided in that case that it was not a fair use, but I think it raised a lot of issues of, what if the lexicon had been different? It may have qualified, and I think it was, in certain areas, a close case. But it's an important case for Warner Brothers, I think, and other copyright owners to demonstrate that whereas we have a lot of tolerance for fan activity and we encourage it to some degree, there are limits and that needs to be observed. So, thank you.
So before I open it up to questions, I'm going to take my moderator's privilege, and I want to start by asking a couple of questions about commercialization, since that seemed to be a very important theme. And one thing I want to highlight, of course, my interests are in the non-commercial side, but those companion books that you pointed to, the dozens of them, are in fact commercial. And I should disclose, my high school debate partner edited one of them, Harry Potter and International Relations. And I have to admit, when I saw the cover, I sort of wondered whether he would be hearing from you guys. I don't know if it was up there. I couldn't see it. But
It was.
yeah. And we all know, of course, that fair use is not just for non-commercial activity. So can you talk a little bit more about how you think about commerciality and its interaction with the other factors?
Sure. I think one of the beauty of our fan policies is sometimes you don't have to get into complicated questions of whether it's really infringing or not, or whether it's fair use or not. What we say to a lot of fans is if you regardless of whether it's a fair use, if you don't merchandise what you're doing, or you're not selling anything, or you're keeping it for free, which a lot of the times is their intention anyway, then that works out. That's an accommodation.
But one of the things that Warner Brothers has basically de facto done is that if a site is earning money to cover domain registrations or hosting fees or something like that, either by being an affiliate of the WB Shop or the Noble Collection or Amazon.com or something like that, and has that small, tiny degree of not commerciality in the sense that they're selling something, but it's certainly commercial in the way that we may have thought about it in the mid-90s or the early 2000s. But at this point, at the very least, Warner Brothers doesn't react that degree of earning money for a site rises to the level of commerciality that makes you guys freak out.
That's right, and thanks for pointing that out. Yeah, we recognize that certain fan activities and fan sites is a good example. Depending, again, on the activity, sometimes there are costs involved. And if we didn't allow the site to run a few ads or raise a little money, they wouldn't be able to do the activity. And so we do accommodate that.
So let me push you on that a little, because I still want to talk about those companion books, because it isn't generating money to run the site. It may be generating money for a conventional publisher. So again, how do you think about balancing? So what makes Harry Potter and International Relations different from the Harry Potter lexicon?
Well, I think in the case of that particular type of book, that probably would have been determined to be a fair use.
Because it just didn't use enough? I mean, because there's a commentary, or?
Well, I don't know if the particular book, but I mean, if something is criticism and commentary and doesn't take too much of the underlying work and doesn't affect the market for the copyright owner, then it's going to be fair use.
Fair enough. And actually, I was going to ask Heidi to talk a little bit about conventions, because what's interesting is in the pre-digital era, we have all these fan activities that do make money. So people sell fan art at conventions. People made and printed zines, and those were well understood. And people would actually sometimes they would at least cover their costs, and then sometimes make a small profit. So how as a fan do you think about that? If we defend non-commercialization, are we sort of kicking those people under the bus?
When I first started getting involved in FanCon organization in 2000, we started working on basically what was going to be the first Harry Potter fan convention, which was Nimbus in Orlando, well before the Wizarding World was even a glimmer in any fan's eyes. I don't know what you guys were doing. But we started working on having an event in Orlando, and we started planning it in the spring of 2002. And about 3 weeks after the organizational team started getting in gear on finding a location, et cetera, Paramount raided a Star Trek convention, shut down the dealer floor, and seized stills that the various actors, with the little tiny bit parts, the random red shirts, were signing, because the stills were taken from their clip on the show, and they said that they were infringing on Paramount's copyright. This was terrifying because we didn't know what we could do in terms of having a Harry Potter fan event. We knew we could have discussions, but we also knew that to be able to have a space that was big enough for us to host everybody who wanted to come, we needed to be able to pay either a hotel or a convention center. So we basically worked it out so that we were bringing in money to cover the meals, and because we were paying for a certain number of meals, which was going to be totally non-infringing because it was pizza, that would basically create a situation where the hotel gave us the rest of the room space, and anything that people wanted to do in terms of room reservations was awesome, but we weren't handling it. We weren't making those room reservations. So we tried to create a way to have a con where the money that was coming in to the event was not covering anything that would be related to the product itself. Over the following year, we had a lot of discussions with Neil Blair. We had discussions with some awesome people over at Warner Brothers. It turned into a very fantastic multi-year, decade-long working relationship. But when we were originally doing the planning phases, we wanted to create a con, as I said, where the money wasn't going for anything Harry Potter related. It was going for pizza. It was going for lunches. It was going for brunch.
So again, let me just explore that.
We borrowed zines from the vendor brand.
So that's an interesting thing. So that's essentially saying that in adopting a certain level definition of non-commerciality, you're sort of excluding some things that don't work unless they're sustained. And it's interesting to hear Dale say, well, we understand, running a server costs money, so there's actually some room for that. It's given some of the discussions that have been going on over things like the Veronica Mars Kickstarter, there's a lot of question about, what exactly is it fair to ask of fans to put into something? And in some ways, fans and big content providers are actually both in the situation where, in a lot of cases, the only people we think it's okay to make money for are Google and the ISPs. And they're the conduits and the hotels that are making all the money, but the creative work actually isn't going on there. So it's a little odd to have those people and the pizza company as the people who can make money off this convention. It doesn't seem necessarily to be in the interests of either fans or content companies for that to be the case. Actually, before I put it up, I want to ask one more question, which is, it sounds there are some areas where fans and corporate owners can agree on, and I want to ask about two. Just your opinions. Should there be a right of publicity? Right. I was interested in your list of things that were not okay. There was a brief fleeting mention of Ellen's right of publicity, but in fact, it seems like for Warner, copyright and trademark. Right. Copyright and trademark are really what you want, and the right of publicity is basically a thing that other people throw at you to stop you from doing what you want.
Right. Well, I'm being facetious, of course, when I say that. I mean, I guess there's a right of publicity. There's a place for a right of publicity somewhere in the world. That our view tends to be that it should be limited to really celebrity endorsements types of things. And the law in this area has gotten way out of control in terms of the video game cases and the cases like The Perfect Storm. I think that people talk about overreaching. I think that's an area where there's a lot of overreaching on the part of individuals and more often the heirs of deceased persons. Does that answer your question?
Yeah. So, and then just let me ask the two of you, what do you think about small claims for copyright? So it's one of the proposals that the Register is now floating, and it seems of interest when you have sort of big company, individual producer, user interacting. Is the small claim something that is of interest to you, or is it actually going to bring copyright in a place where it probably doesn't fit?
I think it's horrible, in part because so many of the people who are using and starting to develop their own creativity by basing by basing their stories, by basing their videos, by basing their art off of things that already exist are teenagers. I'm the mom of a 13-year-old, and I know the stories that he's writing are influenced by Percy Jackson or influenced by Harry Potter. And for him to be put in a situation where he has to, I mean, he's my kid, so he understands copyright law, and so do most of his friends, because I make them understand, no, they can't download movies while they're on my Wi-Fi, but they absolutely can upload fan fiction while they're on my Wi-Fi, because they're completely different things. So for a situation like that, if it's not done hand in hand with a very easy, very obvious, very cheap licensing scheme that allows the person to take the creativity that they want to put into something and mash it all up together, sort of in the same way that YouTube right now, if somebody puts a claim against something, if a company puts a claim against a video or a fan film or something, you can either block it from being viewed on mobile platforms, or YouTube can block it from having ads where the ad revenue goes to the person who uploaded, or they can put ads on it so that the ad revenue goes to the multinational corporation or the copyright holder or whoever is...
Or whoever filed the claim, whether or not they are the copyright holder, there's a little bit of trouble there.
Exactly. There's a lot of trolling going on there. And that sort of a situation, if that could be expanded to a wider universe of kinds of websites where it's very easy and nominal cost or free to be able to take that, and where you don't have to pay because your video goes viral and you get 1 million hits, and my God, you only expected that you would have to pay $3 to be able to use this, these movie clips in your vid.
So, does Warner have a position yet, or do you have a personal opinion on small claims?
Well, it's something that we're looking at. I mean, I think we sort of want to see maybe what the Copyright Office comes out with. But I can see it, for now anyway, it doesn't sound like something we would use to pursue infringers. We'd probably be more on the defensive side of that. And that may not be a bad thing. I mean, if there's a quick and cheap forum to resolve some claims, like, for example, the illustration on the cover of the prop in the movie. I mean, I understand a lot of photographers' organizations are in favor of this small claims idea, and that might be a place that they feel comfortable to pursue a claim like that, as long as it didn't involve any injunctive relief. Maybe it could work out in some situations.
So I'm sure we have audience questions. So I think there are microphones, is that right?
So the regime that you were sort of describing earlier seemed to be, there's a world of fair use, and then there's a world of kind of, whether or not it's fair use, it's something that you institutionally bless or are not willing to, or aren't going to engage legally with. And I was wondering, kind of from both sides of the equation, how much of that is explicit and something that a fan can be aware of beforehand, or how much of it is, you sort of, what it sounded like you were describing was, you see these books as they kind of come across the transom, and you do an internal analysis and decide how to handle it. Do you give guidance to fans that is sort of explicit about what they can and cannot do, or are fans sort of in a position where there's this folk understanding of what various rights holders do, and you kind of hope that you're working within that?
Most of the folk don't understand it at all,
right.
Unfortunately. And that's why things like the OTW and on LiveJournal, there's fandom lawyers, and a former colleague of mine and I have just put together an FEAC copyright Tumblr, where we talk about some of these issues in ways that we're trying to reach people of basically of all nationalities, of all education levels, and of all ages, so that we can basically try and reduce fan paranoia. Because if somebody feels that they're going to lose their house, their computer, their education, their possibility for a future job because they've written fanfic, then that really has a chilling effect on somebody's A, creativity, and B, their ability to become a better creator. And that's just unfortunate in a personal sense as well as in a legal sense, because that's actually not the case. And I think that more fans have become aware of that over the last, 5, 7, 10 years because of things like the OTW and chilling effects and EFF, et cetera, and also the lexicon case, which I know Dale talked about, but the end result for the lexicon case, while it said that certain sections had taken too much content, it also said that other sections hadn't taken too much content. So if you looked at the case itself, it actually gave a lot of guidance for people in New York as to where the parameters would be for a nonfiction work like that. But because so much of fan creativity is fictional, then it really is interrogating the text from a very different perspective.
So, from our perspective, it's it's a little bit tricky. We used to have, we still on occasion use some fan guidelines for people. It's kind of years ago now when fan activity was really more about people getting together with their friends and dressing up like Harry Potter and having parties, or maybe having a little weekend festival in their local community. What's difficult about trying to provide any rules it needs to be so flexible, and everything's changing all the time. It almost seems like every day we get something new, and so we don't want to issue any kind of rules that might be misinterpreted or be outdated in a week, and we don't want people to come back at us and say, well, you said, if circumstances change and maybe we have to adjust things. So I know that doesn't sound very satisfactory to fans, but my experience in talking to fans has been that they kind of get it. And we do spend a lot of time talking to fans. A lot of them seem to understand the parameters, and it's sort of like with our fair use law. Sometimes people complain that it's not definitive enough and it's too hard to understand. But when you step back and you sort of look at the results, somehow it works. And I think particularly under American law, it works well. And because of its fluidity, because of its flexibility, and it is in a lot of ways more flexible and more accommodating to users than I think the corresponding fair dealing laws in a lot of other countries.
Hello, this is about some of the Warner Brothers concepts you're applying in terms of determining whether or not certain creators are legitimate. There's a couple of those factors that seem interesting to me, and I kind of wanted to probe what the kind of the background concepts involved are. Particularly, there was one issue brought up as whether or not someone's a legitimate fan in terms of whether or not they should have a right to create things, and another was, again, just kind of coming back to the commercial issue. If we can bring both of those to the context of, say, a Harry Potter musical, and say you have this exact same work, the product that's produced is the same, but you have different situations. On the one hand, there are people who are involved at a high level in making it who are doing it just to showcase their musical talents, who aren't really very interested in Harry Potter, versus people who make it because they're Harry Potter fans. And on the other hand, a Harry Potter musical goes up on YouTube, and the creators don't make any money off of it, versus it goes up on YouTube and there's a revenue sharing program and the creators make money off of it that doesn't have to go to covering costs they incurred, but just because they can. Why are those factors significant from the perspective of Warner Brothers? Is it just about kind of fairness, or because it doesn't seem like either of those would affect Warner Brothers' ability to capitalize on their own market?
Can I just briefly touch on the, genuine fans or legitimate fans issue? Because I've known the guys behind a Harry Potter musical for years. And they are definitely coming from the, fandom perspective. I mean, Nick and Brian have always said...
So what?
Well,
why do we care?
Well, in this case, it matters because the genesis of the story came from Nick and Brian, a couple of their friends, discussing what would happen if Draco was really in love with Hermione, which is true, but that's a completely side topic. So that's where the genesis of that story came from. And I can see situations, I saw situations where people wanted to do, say, Harry Potter ballets, where they were selling tickets and the people who were choreographing it and the people who were doing it were not necessarily doing it because they were Harry Potter fans. And it may not have qualified as fair use because they were using the Harry Potter elements to basically drive publicity to the presentation or the performance. Whereas something that's created by fans for fans and without the intention of being commercial, even if it becomes commercial later on, I think comes from a different operating perspective.
But we're still excluding the middle term, the stuff created by fans that is commercial, right? And this is where, if this is Harry Potter international relations,
right.
I understand you haven't reviewed that particular one.
Or fan cons in general, which really at this point there is an element of commerciality in it because you need to have seed money for your next event. You need to be able to pay your vendors. You need to be able to have free Wi-Fi for everybody or they'll get cranky. And because you have that overlay on it, it's a situation where you do want to push yourself up to the line, and if Warner Brothers feels like you're going over it, they have a tendency to tell you, but they also do not have a tendency to shut you down.
Well, so, I just want to make clear that there's obviously a difference of opinion. I think it's a mistake to judge how good a fan someone is.
By whether they're commercializing the property. I agree.
So in particular, maybe I would agree with you if I saw the ballet and I said that doesn't actually comment on Harry Potter. But I kind of want to look at the outcome rather than, because God knows I've been accused of being a bad fan because I don't do fandom in the same way as other people do. So, fans are more vicious than Warner probably ever could be about other fans. So I just want to bring it back to the content rather than some judgment of the person's heart. I don't think that our business is to be George Bush looking into somebody's eyes and figuring out.
Yeah, and I'm sorry, maybe I didn't articulate it well enough. But when I said about things having a fan soul, I think it just helps us get to a place in a classic situation where a fan is using our property and it would clearly be infringing. If not for our, from a legal analysis standpoint, it would be infringing, but it's something we decide we wouldn't object to. I think it helps us sort of get to that place where we can say, this is fans having fun with the property, as opposed to someone who, is posing as a fan activity, but they may have more commercial intentions involved. We have had a couple of situations like that. But when I speak to the fans, for the most part, it comes across right away that they're doing this with a group of other fans, and it's coming from a real genuine place, and they just want to know what they need to do to be able to do it. They really want to do it. And so, we usually have a great conversation where we sort of work it out, and it's all fine. And then you don't, and like I said, part of the beauty of it is sometimes you don't have to get to all these fine distinctions. And I'm not talking again about, like the first panel did, what the law should be, or, how it should be different maybe in a reform of the Copyright Act. We're trying to operate within a world of what the law is. is.
And it's definitely good for the fans to push the lines. I mean, from the fan con perspective, one of the very first things we were told was that we couldn't have a costume contest. And I know that that was part of the general rules for fans for a long time, but I don't think it's part of that stricture anymore because no one seems to have mentioned it in the last 8 or 9 years. So by pushing the line and having basically de facto costume contests and costume competitions so that cosplayers could show off their creative skills, we incorporated that sort of thing into our event, even though we had been told that that was a line that we should not be crossing. And again, it was in a commercial context.
So going back onto the commercial side, sorry, I've been here for like a bit. Anyway, so for the corporations more on, but then it's kind of a co-joined thing. Has the corporation tried to, in a sense, make the fans contractors in a way? And what I mean by that is that fans create some brilliant works. Has the corporation decided to develop a department where they will routinely scan the internet for these good works and then be the first to commercialize? With the Harry Potter lexicon example, if it was good enough to attract independent publishers, then Warner Brothers might have wanted to get first dibs on it. And so by doing that, essentially encourage fans to create things that benefits the company, and by essentially finding licenses for these fans to establish what kind of things are allowed and what are essentially frowned upon.
You guys have the last word with this answer.
I can't think of any examples where we've actually done that, and I'm not aware that, we have a department, that goes out looking for talent. But I believe Heidi has some success stories of fans that have turned their fan activity talents into something.
Yeah, there have been fan-created scripts for Doctor Who that have won contests. There have been fan art that has just been taken, the BBC has found on Tumblr or on DeviantArt, and has now obtained the ownership rights to it, or at least the license to it, and they're selling it. There have also been authors who've come from fandom and who have gotten their agents, to a certain extent, based on what they've written fanishly, and now have written original series and original novels, and some of them are being turned into movies, and some of them are still in turnaround. And that sort of thing is awesome because really it's given, fandom has given people a chance to explore and build on their own creativity and learn how to write and learn how to draw and learn how to edit and learn how to work with other people on creating a product or
And of course there's
a showcase.
Darren Chris on Glee.
Yes. Thank you so much.
So that.
We have one more? Oh, great. Then there's a young woman over there.
My question actually piggybacks on his question really well. Is it feasible, or has anyone ever brought up the idea of doing sort of a SAG or AFTRA kind of union or guild for prosumers or for fan fictions? I don't know how feasible that would be, and I know that that comes with its own sort of set of problems, but I was hoping that Heidi and Dale could comment on that.
I think to some extent a number of fans still have a concern about using their real name in a fanish context because they think it'll be frowned on, or they think that it will cause problems for them getting jobs, et cetera, later on. And I think that's becoming a smaller and smaller issue in most entertainment-oriented things, but there are still people who, for example, are teachers who cannot get jobs in certain schools because of what they've written that's online, or at least they feel like they can't if their real name was connected with it. But I think Rebecca can also talk about how important the OTW has been in the last 5 years to basically not necessarily be a guild of creative fans, but be an outlet and a way station for creative fans, both to get information, to share information, and to be a voice that's definitely worth reckoning with.
Well, I feel the tension both ways. I don't want sort of fan fiction to make us poor, in that keep us out of the commercial economy. On the other hand, I think there is more life than the commercial economy, and thinking of everything as a situation where it's only worth doing if there's some ultimate profit for money is probably a bad idea. So the union would have to be a pretty non-commercial union for me to be interested.
Yeah, that's an idea, frankly, I hadn't thought of before. I mean, I know there are existing talent guilds that fan creators could join as they are. So, but I had thought about the idea of a separate sort of a organization